Our show it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is dealing with real estate in divorce. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. You can find us on YouTube, Facebook, and X, formerly known as Twitter. You can find us on each of those platforms at the handle @INREM Podcast. That's @INREM Podcast. Also, if you want to download an audio version of the podcast, you can go to Spotify, Apple Podcasts, or any other platform that host audio podcasts. Download it, leave us a review. We would appreciate it. Helps us out a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is answering the question of when do you need an LLC operating agreement? So LLCs can be formed fairly quickly with the proper state agency of whatever state you want to form it in, whether that's here in Arizona, Wyoming, or any other state. And you basically fill out articles of organization and you submit them and you file them with the state, and then they stamp, they approve, they say, okay, now you have an official LLC. But behind the scenes, there's a document that is called an operating agreement, which basically controls the operations of the LLC. It also provides for information regarding ownership of the LLC, you know, who owns what percentage of the LLC. It provides for management of the LLC, who are the managers, who has the ability to run the LLC. It basically governs the full operations of the LLC, but you do not need an LLC operating agreement to create an LLC. You can form an LLC and it will be validly formed with the state that, it's formed in without an operating agreement. So the question is, well, then why do we need an operating agreement? And there's, what I found is really two main situations for an operating agreement. There's others as well, but where my clients tend to miss the boat when they come to us and they're, trying to close on real estate, or they are trying to, organize or set up their organizational structure, and they've already started a little bit by forming some LLCs. The two areas that they miss the boat on and they don't have operating agreements for are when they form the LLC in an anonymity state. So that would be in Wyoming, Delaware, and there's a few other states, New Mexico. They go and they form it, but they don't have an operating agreement, and that's a major problem. And the reason why it's a major problem is when you're forming in an anonymity state, you are basically submitting articles of organization that simply state the name of the company that you're forming, as well as the registered agent of that company in the state where you're forming it. The articles of organization do not have anything regarding the owners of the LLC, or what we call members, the managers of the LLC. It's void of all of that information. So the only way when you form in an anonymity state that you know who owns the LLC or who manages the LLC is to have an operating agreement. And you must have that operating agreement in place to operate an LLC that's formed in an anonymity state. And the reason for that is because you need the protection of the corporate veil. If you're out there transacting on behalf of an LLC that doesn't have any members because you don't have an operating agreement or doesn't have any managers that can act on behalf of the LLC, then basically you and the LLC are one. You haven't created that corporate veil that the operating agreement would provide to protect you and keep separate the LLC from the individuals who, own it and manage it and operate it. And that's what that operating agreement does. It says, okay, this individual has the authority to act on behalf of the LLC. So when they go and sign something on behalf of the LLC, they are doing it under the power given to them by the operating agreement. But if you don't have an operating agreement, then arguably they are executing contracts and loans and other documents, basically in their individual capacity or on behalf of an LLC that really doesn't even truly exist, because the operating agreement, there is no operating agreement defining who those members and managers are. So that's one area. The second area that is problematic that we see is when you have multiple members who have different ownership percentages. So for example, one member is going to own 70% of the LLC and the other member is going to own 30%, or maybe you have three members and one member is going to own 60% and the other two members are each going to own 20%, or, that type of thing. It's not going to be 1/3, 1/3, 1/3, or it's not going to be 50-50. It's a different percentage of ownership. And so, they go and they form in a state like Arizona, which is not an anonymity state. So when they fill out the articles of organization, they list all of the members, all the owners of the LLC on there. Well, the default or the presumption is that each owner has an equal share in the ownership of the LLC. So, if there's three owners, then each will be deemed to have a 1/3 interest in the LLC. If there's two owners, they'll be deemed to have 50-50 ownership. And then they go and they operate without an operating agreement. They start paying distributions based upon, a handshake that they have saying, oh, well, you have a 60% interest and I have a 40% interest. And they go and they operate that way. But that's problematic because that's not what the default is. That's not what the state recognizes as the ownership. The only way to change that default provision within state law is to have an operating agreement that defines and overrides that state presumption of an equal share of ownership amongst the members. So if you have multiple members of an LLC that are going to have differing percentage of ownership, then you must have an operating agreement that defines that. So when you need an operating agreement is twofold. There could be, once again, other times, but it's twofold. So first, when you form in an anonymity state, and then second, when the members have differing ownership percentages.
All right. Thank you, Sean, for the legal update. With that, let's get into some announcements. Join us today at 2 p.m., and that's every Tuesday at 2 p.m. That's Arizona time, 2 p.m., for the Creative Finance Collective. What is the Creative Finance Collective? That is a group of lawyers, professionals in the space of creative finance. We get together and we talk about all things creative finance, subject to purchasing. And what we're doing is trying to learn from each other from the perspective of different jurisdictions. So we've got lawyers that come from and participate from Arizona, California, Alabama, Georgia, Texas, Ohio, from all over the place. But there really is kind of a niche group of lawyers that are in this space. And we get together and talk about creative finance. But what we do is make ourselves available, captive to you for an hour to questions. So if you are a real estate investor, or you're just now thinking, boy, I've heard about buying real estate subject to, I've heard about this thing, creative financing. What is it? What does it look like? What are the risks? What are the rewards? What is it about it that everybody's talking about? This is an opportunity for you to talk to lawyers in the space, to get an idea about it and ask us questions. Like I said, we're on for an hour or for as long as we're getting questions. So it's important for you to be there and engage with us. We appreciate it. And it's always a good time. We enjoy having you and having the questions. With that, also, make sure if you have questions for today's episode and questions for our guest or Sean or I, make sure to post those in the chat. So we'll take questions in the final 15 minutes of the episode, but you don't need to wait till the final 15 minutes. You can post those questions now. We're monitoring the chat, and we'll pull those together. It's important for you to do that now because you'll forget come 45 minutes from now or so. So make sure to post those, and we will get to those questions. All right, so we're going to get into our topic today. So we're talking about divorce, and you're thinking, well, why are we talking about divorce? This is a real estate show. Well, divorce, in our experience, has massive implications for your real estate. And divorce, unfortunately, happens to be a prominent thing within the society at large. It's something we have to deal with. It's something we have to face, whether it's you facing a divorce or whether it's you as an investor looking at property wrapped up in a divorce. You need to understand the legal implications for that. And today, to discuss the matter with us is Wisconsin attorney Kyle Kaufman. Kyle, thanks so much for being with us.
Yeah, hey, thanks for having me here. Really excited to talk to you guys about this topic.
Yeah, we're excited to have you. So, Kyle, tell us about yourself, your law firm, and how you got into doing what you do.
Yeah, absolutely. So, as you said, we're a law firm that's based in Wisconsin, HKK Law Offices. You can find us at hkklawoffices.com. Our legal name is Hawley, Kaufman, Kautzer. But we're in this process right now of this kind of rebrand and shooting out this HKK Law Offices. So let me tell you a little bit about my background. I've been practicing now 18 years and found my way into family law. Frankly, it wasn't my original intention, but found my way there because I was always good at listening to people, really finding out what their problems were, what their issues were, and trying to help them find solutions to that. And what happened is that over time, the phone kept ringing, and it happened to be people that were in need of family law help. So reluctantly, really kind of went into it. And our firm at the time was really a general law firm, and we covered a lot of areas of the law, but we were doing a lot of work in criminal at that time. And that was really my background out of law school. But at some point in time, I recognized that the calls were coming from these family law clients. And I can remember my very first one, and I had that client for about 24 hours before I turned it over to our senior attorney. And I did that because I discovered very quickly that there was a lot of work, a lot of complexity to it. And I did not feel quite qualified at that time. That was years ago. And as I got more into it, what fascinated me about family law was that there's several intersections in family law, including with things like real estate, taxes, cash flow, finances, debt, assets, just all sorts of things that you learn, and you learn from your clients because you have clients, some that have a lot, some that have nothing, some that had a lot and lost it, and some that are gaining it, right? So we really became interested in what we could learn about ourselves as lawyers and people, and as a law firm, and started kind of growing with our clients, so to speak. And really, the way that we describe it is really transformation. So personally, I felt as if I was going through this transformation and learning so much. And then I just wanted to absorb a lot and figure out, hey, if this person did it, I think I could probably do it. And that trickled down to the rest of the law firm. And now we are solely focused on family law. We had handled some estate planning items as of this year and just recently decided, no, we're just going to strictly focus on family law. We cut off all criminal work last year. So we're really super focused, and we're excited about that. And we're growing right now. So we have 3 locations, and I'm sitting at our newest location, which is in Mequon, Wisconsin. And none of us live here. We don't have any ties to this area other than practicing here from time to time. But the exciting thing for us is just that, discovering this community, learning how things work here, meeting people, establishing relationships. And ultimately, what we want to do is improve communities. So at our law firm, we run on EOS, if you folks are familiar with that, which is the Entrepreneurial Operating System. I'm happy to talk more about that if you guys have questions on it, but it's been wonderful for us, and it's helped us to see the bigger picture, have greater vision, and want to help. Yeah, go ahead if you have any questions. I want to tell you just a little bit about on the real estate side of things. As I learned along the way, my law business partner and I have some real estate things together, but then on the personal side, I was able to get my wife interested in this, and we decided to go out and basically take the thoughts and ideas that I had maybe when I was 20 years old. I'm 43 now, and start actually putting those into process. And we've been able to get involved in some multi-use properties that are mixed commercial and residential, and some other commercial properties, and obtain some passive income from that. So that's exciting, and still learning in that area of real estate as well.
Yeah,
So
very
it's
cool.
a little bit of background.
Yeah, we understand that, you've and it sounds like with the mixed use that you are a real estate investor yourself. What originally got you into doing real estate investing from your family law practice?
Well, I think it was always in there. I don't know exactly when that happened, but like many real estate investors, right, read Rich Dad Poor Dad somewhere around 18, 19 years old. And I can remember kind of pulling a buddy in and being like, hey, meet me downtown, right? And he did. And I said, let's just walk up and down, and let's like identify all the ways that we could improve this, like invest in real estate and make passive income. And it's not going to come today, but it'll come tomorrow. Well, we never really got that off the ground. I understood the concepts of it, but I was not surrounded by people that were real estate investors. And so much is in your environment. And so that was problem number one, really, for me, right? Anytime I would ask or bring it up, it was generally people would say, well, no, that's not for you. Just go be a lawyer, so on and so forth. And then I really think a lot of it had to do with the type of work that I was doing and the interesting things that were happening. And man, we live in a great time now where there's so much information you can get from podcasts like yours, from YouTube channels. And I just started learning and absorbing it, taking what I was learning, seeing what my clients were doing. And then I just started putting feelers out there to other real estate investors who wanted to do deals. Maybe they were looking to scale up. They wanted to get rid of something. And that was kind of my approach. I thought, well, if you want to go there, maybe you can help me with the cash flow down here. I can get you to where you want to go. You can get me started. And that's really what triggered it. The first deal for me probably took a while to work down that line of certainty. And I remember going to bed the night before thinking, what am I doing here? And not getting much sleep, and signed the documents the next day. And then I, had cash in my account from the deposits that we inherited. And, it was like, well, suddenly I was sitting on cash, and it came in on the first and on the first thereafter. So it's much more tolerable, I think, once you jump in the pool, right? You get used to the temperature, and it's more fear than anything. So I was getting past that.
No matter what they tell you, going into this as a lawyer doesn't suddenly make it easier, does it?
No, it doesn't, right?
We still have fears too. Maybe more because we're more acutely aware of the risk.
Exactly. You overthink it, and you think, is this my place? Or, man, I've only seen the bad things. That's the other part of it. For a long time, I represented a lot of landlords, duplexes, fourplexes, things like that. And they would come to me and they'd say, can't get this person out. Can you help me get them out? I can't get their stuff out. Can you help me get their stuff out? And it's a bunch of headaches. Now, I will say that did help me down the line, because I thought, well, I've got that part covered, right? I've got that back end of like when it goes wrong, I felt like more confident about how to handle that. But that did take some years of service, probably as a lawyer, to get used to it.
Sure. I understand you're a host of the Meaningful Ideas Trading Club. Tell us about that.
So the Meaningful Ideas Trading Club is I'm excited about the future of the Meaningful Ideas Trading Club. So this came out of, I was in a mastermind group, and we would meet once a week. And I put a lot of time and energy into this mastermind group, this other group that I was involved in. And so they asked me to come and speak, and they have a big audience. They asked me to come and speak, and I said, sure, but I'm going on vacation with my family. It's the only thing I'm doing on this vacation that's not family related. And so when it came time for me to join the program, and I got all dressed up, I'm sitting there, my family set aside its time. We didn't go to the beach, that sort of thing. They never called me into the room. And I sat there and I was like, what's going on? Like, okay, maybe, the next break, and so on and so forth. And I sat there for an hour, and nothing happened. And so I was not upset with the program or the producer or the group. But I guess what upset me, it really kind of threw me off, it was probably a life-changing moment for me, was that I just felt like whatever I had to say that day did not have enough value. It was not important enough to the group that they made sure to track me down and bring me in. And so I wanted to go out and basically establish my own group, my own mastermind of people that could come in and really bring value during the program. And for the people that were contributing and coming in and talking, that they felt respected. And so that was the initial thought with the Meaningful Ideas Trading Club, and very wide. And, we wanted to just talk about personal and professional development and break down the barriers of, you have to join a country club to have conversations with high level people or have these deep discussions. Right. And we kind of wanted to shine a light on it. So I've been running that for over 2 years now. We do it once a week, Thursdays, noon to 12:30 Central Time. And we run it live on Zoom and Facebook Live. I've recently kind of migrated into a new role in our law firm, which opens up some time for me. And one of the focuses here for the Meaningful Ideas Trading Club is to get much more narrow in how this can help people and bring value to their days. I figured there was people that I listened to along the way, and there's lots of speakers out there, lots of people telling stories, and some just resonate with, some resonate with some people, others don't, right? And our program might not resonate with you, but it might resonate with your neighbor, right? And so we wanted to be a voice out there and be somewhere that it works for somebody. And we've seen some of that. We've had what I would call the Hall of Famers in there that their businesses are really starting to scale up now, and they're doing some great things. So yeah, thank you for mentioning the Meaningful Ideas Trading Club. We intend to expand on that and really bring it into focus in the next couple of years.
Yeah, very cool. All right, so let's get into our topic today. We're talking about divorce more broadly, but even specifically divorce, how it impacts real estate. So as we focus and scale down onto the top of real estate specific, let's keep this thing at about 30,000 feet for those who maybe have never been privy to a divorce, haven't been a part of one directly. Let's break down the common issues that one would expect to see and the common issues that need to be decided in a typical divorce case. Can you break that down for us?
Yeah, sure, definitely. So first off, Sean's comments at the beginning about an operating agreement oftentimes are analogous to a marriage, really. It's two people who are coming together and bringing assets and debts together, and oftentimes not defining what that means at the outset. They're just joining it. And what we see at the time of the divorce is now we're taking it apart, right? So at a high level, I view divorce, it's essentially a lawsuit. You can file a joint petition. Two people can say, yes, we want to be divorced, and file it together to get it started. But essentially, you're suing each other for the right to your property, your real estate. If you have children, the right to see your children. It's kind of a nasty way of saying it, but at the end of the day, it's really what it is. And somebody has to decide how to divide these things up. And when I say things, obviously children are not things, but we have to decide how to deal with that issue too. And so on the asset side of things, the main issues, well, before I get to that, there's really the cases with minor children and cases without minor children. In the cases with minor children, really what we're looking at there is primarily the kids first, right? In Wisconsin, the terms we use are custody and physical placement, and then the financial support issues related to kids, child support, health insurance, uninsured medical expenses, child tax credits, and exemptions. Then in any divorce with minors or not, of course, we're going to look at the assets and debts. And the assets that we're generally looking at, people would describe as their homes, their bank accounts, businesses if they have them, real estate investments, retirement plans. And then, of course, we have the debt aspect of it too, which needs to be divided. So those are the main issues. And of course, I guess what I would call the cash flow, which are the maintenance or alimony, depending on the state that you're in. Spousal support.
Okay, so now at the end of the day, when we're talking about the assets, it's a judge's determination unless the parties can agree otherwise on how they're going to equitably allocate the assets. So specifically when we're talking about the home, the real estate that we're dealing with, my understanding is that there's we all kind of assume this discussion just jumps forward to post decree after the courts finally made a decree and how everything resolves at the end of this. But really there's determinations that happen early on in the case pending the divorce. So what is the court usually doing in determining what's going to happen with the real estate, or specifically the marital residence, during the course of a divorce proceeding?
Sure. Yeah, and I just want to comment on, judges ultimately can decide these issues, and that can be after a contested trial, right? Two sides disagree, can't figure it out. And judges also have to approve the agreements of the parties. So those agreements of the parties do have to be equitable. And you use that term, Andy, and that's a key one, because sometimes people come in and say, well, could we just do this? Could we just do that? Yes, you can propose it that way, but ultimately the judge does oversee this in the state of Wisconsin, and you have to appear personally before the judge, be sworn in under oath, and the judge will review that asset allocation to make sure it is equitable and ask questions if there is some disparity in that, which you can have unequal allocations as long as they're justified. And we might get into that here in this conversation. But with respect to the house, I think what's really important for people to take from this is you have to have a plan for yourself. I read that in a book once. Nobody is planning for you, and especially in divorce. Although you're getting a divorce for whatever reason, it might be amicable or it may not be, but loyalties really just tend to fade like this over time, right? And people when this divorce starts, they might be in the home together and they're seeing each other every day. And it's like the frequency of how often you go to the gym, right? So if you're seeing your soon-to-be ex-spouse and having these conversations, you guys might be more aligned. But the further apart physically that you get, the less communication that happens and the less loyal that people get. People really do start looking out for themselves in this. And they try to sell it. They try to say to the other side, I'll be your friend, don't worry, and so on and so forth, right? You can't trust that. You do have to have a plan for yourself and create certainty for yourself. So how do you do that? Well, with respect to a house, a good question to ask right away is, if we're just speaking about just the marital residence, while this case is pending, do I stay in the house or do I leave? And that there's reasons you might have to leave, but I encourage you to think about how much easier it is to keep something than it is to get it back, right? And once you're out of the home, it's like the mind shifts, and the judge's mind shifts of, oh, you're not in the home and she's in the home, or vice versa. And the conversation that just takes that approach of kind of this idea that, well, whoever's occupying it, we assume is going to keep it, right? So some of this, when you file for divorce in Wisconsin, you can obtain what's called a temporary order. And a temporary order is something that generally is scheduled by request usually within about 60 days of the filing. We tell our clients 30 to 60 days. And you can go in then and discuss some of these matters before you get to the time of final judgment, which in Wisconsin, the earliest is 120 days. And you start discussing things like who's going to occupy the home while this case is pending, who's going to pay for the expenses, mortgage, real estate, taxes, insurance, all that sort of stuff. And so you can start planning some of that in those early stages. And, it's really kind of zooming out to decide, do I want to keep the home or not? Right. That's really the first thing. I can go on a little bit more about that. So,
let me back up for just a second, but it sounds like, kind of from a strategic perspective, some of what you're saying is, how you decide things paints a picture a certain way, both for you and your spouse and how you deal with each other, and even for the court. Whether you thought about that intentionally or not, but this idea that you leave, one creates a separation and maybe creates a dynamic that you didn't intend in terms of working things out in the future. Whether working things out means a division of the assets, or staying together, but it has an impact on that, but also has a kind of a impact on third parties like judges in terms of how they perceive the situation when you leave. So it sounds like you're in a sense advocating that as you approach a divorce proceeding, almost like a real estate transaction, it requires a little due diligence to be thinking about what this is going to mean and be planning for that. Is that right?
Absolutely. I'm sure you guys have seen this and your listeners have. Like, if you're putting together a real estate deal, you want to have the least amount of objections along the way, right? You want
Sure.
that path to be, as easy as possible and not create more problems. We tell our clients that, unfortunately, judges are very nice people, but they just don't wake up and say, I can't wait to figure out, Kaufman's divorce today. They just don't. They don't. So our job as the attorneys, as you're saying, is to help with that strategy ahead of time and to make that path that much easier and say, here it is, judge, this makes sense, right? So if you come to a temporary order hearing and let's say you vacated the house, but ultimately you want to get back into the house, now you're not in it. And if your spouse is undecided and you're asking a judge to make an order to have this person vacate, it's that much harder to digest. And now you're concerned about the upkeep of the home too, right? Is it being kept? Can I come back there? Hey, it's falling into disrepair while this case is pending. Normally I would have done X, Y, or Z. So just from physically being present, that's a consideration as to the marital home for sure.
Kyle, so this is intriguing how, day one of maybe a divorce filing and where you're living, how you choose to live could impact the final decree. So it sounds like, if I'm looking at it and saying, well, I want the house sold, right? I don't want my name still on the house. I don't want to still be on the mortgage. I just want it, basically do a disposition, split the sales proceeds. I may want to stay in the house and not vacate, because if I vacate and leave, say, a spouse in the house, they would maybe have a better argument at decree time to say, no, let me stay even post decree because I've been living here the whole time. Is that accurate?
It can be, yes. And if it's really complicated when you introduce kids into it, right? Minor kids, because now the court is mostly concerned about the children and their best interest, and not really the squabbling, if I said it that way, of these two spouses who are, I guess, interested in the home or the financial end of it. So that really becomes an issue and can be very hard, because courts would generally say, look, okay, fine, the relationship is not working out between husband and wife. Does that mean now we have to uproot this for the kids? And they want to keep, the human tendency is to maintain, right? Especially in hard times, just hold on tight, like keep things going as is. So there's this predisposition to say, well, we want to kind of keep the kids in the home. So that does complicate things. And judges really do not want to force people out of their homes. There are times where we do make requests for somebody to vacate, and judges have a really hard time with that. So you have to have some really good reasons. And there's some times where both spouses just kind of hunker down and stay in the home. You can do that while the case is pending. But at some point, when it comes time for final judgment, it will be awarded to one spouse, and courts would prefer that versus forcing a sale, assuming that a spouse can afford it, right? And so now we have to look at what options they have to do that. And we try to work with our clients ahead of time on that to figure out, well, if you want to keep the home, one, is it affordable for you? Can you do it? Well, I don't know. I think the bank will work with me, and so on and so forth. have those discussions. Go have 3 or 4 discussions with different lenders. Get as close as possible as you can to find out if they'll work with you. And again, that's kind of doing that service to a court to say, hey, our client can do it. We know that. I had a trial within the last year, and this guy insisted on keeping the home. And we learned at the trial, he never took any efforts to actually find out if he qualified for any sort of refinance, right? Because my client needed to come off of the mortgage. Never did anything the whole time.
So yeah, that presents kind of a dilemma. And we've seen the back end of this in our real estate practice where our clients come to us and they say, well, so here's what happened. We had this divorce. The spouse that was awarded the property was supposed to pay the mortgage. They were supposed to actually refinance, take me off. They never did. Maybe market conditions, et cetera, didn't, come into play.
Yep.
And now, I've tried to qualify for a house, but because of my debt to income ratio, I can't, plus my spouse isn't keeping up current on the payments. They'll fall behind, then they'll pay. And of course I'm getting dinged on my credit. And now guess what? This property has appreciated $100,000 over the last 5 years. And yet the house was awarded to my spouse. Do I get any of that money? And it's a real problem. And I think in particular, to me, the problem started from the decree and not, putting those safeguards in place. So talk to us about those types of situations and maybe some safeguards that can be put in place for the spouse that isn't awarded the house, but is still on the mortgage. And how do they get off and basically move on with their life?
Sure. Yeah, absolutely. Right. So we need to think about just the asset, and we also need to think about the liability end of it. And in some cases, the equity, right? Because a lot of times the payout is coming from the house. I can remember the times when I started doing divorce cases, and this was around the 2008 time, and houses were like a liability. Nobody wanted the house. Everyone was just trying to sell them, and they couldn't sell. And we've seen it come all the way back around where now people that have the house are trying to get appraisals to show that it's really not worth what the market is saying it's worth, right? Because they've realized this appreciation and now this huge equity payout that they have. So that's a whole different thing about the appraisal and the value we could talk about. But yes, definitely, Sean. So you need safeguards in your divorce decree to make sure if somebody is being awarded the asset, the home, that we've also addressed the liability end of it and said, oh, there's a mortgage, there's a note. You have to satisfy that. You have a certain period of time to satisfy that by whatever means. And if you don't, right, the home then, I've seen cases where there's options where the other spouse could take it and have an opportunity to do the exact same thing if they wanted to. And otherwise it just is sold. So you want to definitely put a time parameter on this to make sure that these things are met. You definitely do not want to sign the title to the spouse awarded the property until those things are taken care of. Our firm became involved in a case where the lawyers in that case and the judge didn't put any provisions in about the mortgage. And prior to our involvement, the title had been passed to the spouse. And now we're trying to deal with this refinance and getting him off the note. And the decree doesn't say anything about it. So you definitely want to take care of that up front and make sure that that's in there. You need those payments to continue to be made, both for if there's a mortgage or note, the taxes, insurance. And if it's not, you want to bring enforcement provisions in there and protect that spouse. And you have to go back to court and show to the court that not only are they not making the payments, but it's been harmful to you. And the court can then essentially lean on that non-paying spouse to take action or surrender the property. So there's definitely steps that can be taken. You want to work with a qualified attorney on that and make sure that you have all of that in your divorce decree.
So if what I'm hearing correctly is if you're about to enter into a divorce decree that basically just awards the property to the spouse and there's a mortgage out there, but that's all it says, that's a problem. And you need to make sure that it outlines exactly what is going to take place to remove you from the property, what the timeframes are, maybe what the penalties are for not doing it. Is that accurate?
Yep. And there can be penalties in there. And essentially the spouse not receiving the property has a lien on it until this is all satisfied. And the other thing is too, is you have to remember the lenders are not a party to the divorce action.
Mhm.
So if the lender, has made a deal essentially with the two spouses to pay it, they're going to require both spouses to pay. And so a lot of times people think they can just go to the lender and say, oh, well, I was awarded the house, take my spouse off. That's not how it works.
Mm-hmm.
Which is why the person who's getting the property has to do some investigation ahead of time to even find out, is this feasible? Can I refinance? Can I get money from another source? How do I do this? And when we're on the other side of that and the other spouse is keeping it, we try to do our best to forecast for that ahead of time and say to the court, this proposal this person's making is not going to work. So here's our solution to it. But yes, you have to make sure that you've covered that.
Yeah. So it sounds like, and this is, we see it once again all the time in our real estate practice where, post decree, somebody comes to us because there's a property issue and they say, oh, well, they were supposed to remove me from the mortgage. And you're like,
Mm-hmm.
So if I hear what you're saying, really, if you're both on the mortgage, there's no going to the lender and having one spouse assume the mortgage and remove the other spouse from the mortgage, right?
Really only if the lender agrees.
Right.
And they're going to have to qualify that single spouse and say, sure, we can do an assumption. That happens. That's way less common than new financing or refinance. So yeah, it's not as simple as just going to the creditor and saying, hey, you have to remove that person. In Wisconsin, and what we do too is because after the granting of the divorce, we do a new deed, which makes the spouses now tenants in common versus a joint tenant because the relationship has changed, right? So that creates different rights now for these tenants in common. So post-divorce, the minute they sign their divorce, that's what we do is say, all right, well, now your tenants in common, sign this new title.
What about the situation where, let's say, the spouses are fortunate and the property's owned free and clear. And there's enough liquid assets to basically do an allocation and give the non-awarded spouse 50% of the equity in the property. And now the spouse that's awarded the property would then own it outright. No mortgage issues to worry about. From a logistical standpoint, do the parties have to execute, or do they normally execute a deed in that case, or can the decree in and of itself effectively convey title?
Definitely should do a new title. You want to make sure that that's clear, that all marital interests are satisfied. So, you really, it's you've gone from, really a union to a single person. So really best to do a new title, new deed.
Now, going down that path here, let's say hypothetically, because that's good. I mean, the spouse will sign the new decree if there's a settlement agreement, that type of thing. But let's say, like you said, this is a lawsuit. Let's say it's litigated and both spouses want the house, and one spouse wins, the other spouse loses. They do an allocation of liquid assets, and the judge basically says, okay, you can keep the house to the one spouse, and they put it in the decree, and the non-awarded spouse says, okay, that's fine. You were awarded it, but I'm out. Like, I'm not signing anything else. I'm not signing a deed. I'm not doing anything. You won, you get it, but that's all my responsibility. Do they legally have to sign that deed? Or what happens if they refuse? They're like, no, you won. It's in the decree. Figure it out from there.
Right. So you do want to put in your judgment enforcement orders that says, hey, whatever the asset is, whether it's a vehicle or a home or something like that, right? That says you will sign documents to transfer title. However, as you know, family courts are not going and pulling these people into their courtroom and forcing them to sign it, right? So how do you get somebody to actually sign it? Well, you do want to take reasonable attempts to do that and try to work with that person to have them sign it. We have had situations where they refuse. So you can bring an order to show cause, essentially bring this person back to court, try to get them before the judge, have the judge put sanctions on them to, compel them essentially to sign it. And if that doesn't work, you can do a transfer by judgment. So a court can approve of that, and you can then take your decree and say, all right, so it was awarded to me and this person essentially is refusing. And we have had to do that a few times in my practice.
So the decree can actually convey title. Here in Arizona, the rule laid down by title companies would be that the decree can convey title, but the legal description for the property must be in the decree to do it. And then you record a certified copy. So, but what you're saying is you can do it, but it's kind of the last resort. Like try to get it a deed so it's clean. But if we need to, we can convey by way of a decree.
Exactly.
Kyle, just kind of jumping back a little bit.
Mm-hmm.
One of the things I want to ask you is kind of a market condition type question. You mentioned, one of the ways that the spouses are going to get one of them off title might be an assumption, but most often it's going to be like conventional refinancing, something to that effect. Well, some might call where we're at in the housing market an affordability crisis. So we were at a time with rising interest rates, followed by a decade or so of almost free money. As a result of that, we have a huge majority of homeowners, many of which are probably and have been your clients, that are sitting on 3 and sub 4% mortgages, right? And they're great. Well, now they're in a divorce. We've got to find a way to flip out the equity onto this thing and refinance out. The problem I'm sure that they're facing, one, you mentioned the real estate's worth more money. So there's a fight over as to how much it's really worth. But one thing that they can't really negotiate is whatever the conventional rate is. And if you're refinancing out of your 3 or 4% mortgage into, let's say, a 7.5%, the dynamics of that are significantly different. So I'm wondering, how often is that presenting a problem to getting some of these deals done in divorce?
Yeah, definitely more and more. And it's also a problem for the spouse that's not getting the property, because a lot of the times they're waiting for the refinance so they get their cash that they can then go use as a down payment to do what? Buy a home. Now they have to face that crisis, right, with the interest rates. So a lot of the solution here is people are deciding to sell the home and use that as an asset, right, to get cash to both parties, and then they're both kind of in the same position. So it is coming up more and more. I don't have any great answers here for how to necessarily deal with that, but you have to be a little bit more creative in your sources of money. And we have had some cases where loan assumptions have been, people are trying that first. Of course, they want to keep that low interest rate, but definitely facing challenges on getting the financing.
Well,
so,
it's interesting. Correct me if I'm wrong, but it kind of sounds like, I hadn't thought about this dynamic, but it almost sounds like spouses are coming to the conclusion that, well, even let's say one of us can assume the mortgage. And we can assume it at 3.5%, and we'll assume that can get done. Is that really fair and equitable to both parties for one person to get the 3% or whatever it is, and the other person to get 7.5 and 8? So the conclusion is, well, none of us should get that. We should all just sell it and start fresh that way.
That sounds pretty fair, right? I mean, there are these scenarios where somebody's saying, well, gosh, I wanted to keep the house. We've had this house. I put my blood, sweat, and tears into this house. Our kids grew up here. You have to help me keep the house. And a lot of times they're asking for some sort of relief, like give me more time to refinance, or do not require me to refinance because of this great rate that I have. And, but it's like, well, wait a second. This other person who moved out, who might be living in a lower standard of living in an apartment that's not, compared to where they were in a full house and a yard and all that sort of stuff, is saying, well, no, why do I have to suffer while you get to continue with this great rate? So, right, a solution is, if you can't figure it out otherwise, you're either going to have to just eat that rate or sell the home, right? But I don't think courts are that sympathetic to that. It is what it is. You wanted to keep this. This is what it's going to take. You're going to have to figure that out.
Kyle, let's talk about some common mistakes that spouses make, both prior to divorce, or even, prior to the decree with respect to real estate. So, we see this in our real estate practice where people do weird things with their real estate, and then they go into a divorce proceeding and they are like, oh, how do we fix this problem now? So what are some common mistakes that you see spouses do with their real estate ownership prior to a divorce decree? Not a decree, I'm sorry, a divorce petition.
Sure. So, and sometimes it's even prior to marriage. So title is an issue. We have a lot of situations where somebody might already own the real estate and now they get married, and they haven't planned for the appreciation, the increase in value. They haven't really thought it through, right? And of course, when you're getting together, it sounds good. I have a house. You can move on in. I'm paying for it, right? Like, I brought the down payment. Don't worry about it. And when things go wrong, that person generally is trying to figure out, now, how do I get my money back? Why is it fair that when, I brought 100,000 to the table when I bought this house, and, it's appreciated and it's now worth, I don't know, $400,000, right? So do we take the full 400 and divide that in half, or what, amount are we using here? And the best way to go about that is through some sort of prenuptial agreement or postmarital settlement or postmarital agreement. A lot of people don't want to do that. Usually that's an emotional thing versus a level-headed thing. And so, perhaps, that's a future for us in our law firm to really develop that, because it creates a lot of problems for people, and they're trying to get their money back. They're trying to, there's an attorney in our office who uses the term claw back and, take this money back.
So what you're saying is somebody goes into the marriage with a house that they bought, maybe they put their, blood, sweat, and tears into it before the marriage, great house. They get married and they're like, hey, let's live here, and then all of a sudden, while they're married, they start, paying the mortgage and paying the utilities and making improvements, and, there's appreciation while it's married. And all of a sudden that, here in Arizona, we have community property and sold and separate. I think it's a little different in Wisconsin, but basically that house that used to be just that spouse's property that they brought into the marriage is now all of a sudden a marital asset to some extent that must be split up in the decree or in the divorce.
Right. At least in Wisconsin, right? Like, so in Wisconsin, the rule is anything you bring into the marriage, unless it's a gift or inheritance, is marital property. So you've brought it in at its value at that time. And now the court has to figure out what it's worth and how it should be divided. And there's some general principles and rules that have been defined with case law over time to help with that, but it's not that simple. And it's tricky. So you do need to be thoughtful about that and thinking how to protect your asset as you go into a marriage in Wisconsin.
What about, and we see this as well on not so much in divorce because our firm doesn't have a family law practice, but just in our estate planning and real estate practices, what happens if from an estate planning technique, which should never be utilized, but they do it anyway, the two spouses say, okay, let's put our, kids on title so that they inherit our property. And now they go and they file divorce and they want to, split or separate the marital residence, but yet the kids are on title. And let's say the kids are uncooperative. What does that look like? How do you even deal with that?
So they have a marital interest, right? I mean, they have now, essentially taken what it was a marital asset, invited other people to the party, essentially, right? And so now we're looking at that marital component of it, and really probably placing a value on that. I guess it would depend on how that is held in title. I mean, you might see this a lot with like an LLC, like when people have a vacation property and they buy that with family, and what do we do now? How do we break that up? And that gets back to your initial at the beginning of this, an operating agreement, which really dictates that, right? So yeah, certainly that can be something that has to be looked at. I want to talk about too, I mentioned gift and inheritance. So, there's sometimes confusion on the debt end of that. So let me say this. So sometimes people will be gifted real estate or they inherit it, and it's titled just in one spouse's name. And they have a choice at that point when they get married to change the title, right? To put it into both spouses' name. They don't have to. And title, we could do a deep dive just on this, but keeping title in one person's name from gift or inheritance is often a sign that it was not donated to the marriage. Okay. But now what happens when that couple says, hey, you got that thing, we've got some equity in there, we want to do some improvements, so let's get a loan, a home equity loan, and now both spouses sign that. Okay. And now they've just created, it's not an asset, but it's a marital debt. Okay. So you could have one person, one spouse who is the title owner. It still has its status as a gift or inheritance, but that note that you took out during the marriage, although it's attached to that, is marital. Okay. And the note does not make now the title to the property marital. I don't know if I.
That makes sense. Yeah, because in Arizona that likely would not happen or occur, just the way our community property statutes are structured. But that is very interesting. So basically, you can have a marital a marital debt associated with a non-marital asset.
Right.
That you have to figure out. So how does that work? Who do they have to sell the house and pay off half of that marital debt, or how does that work?
Well, the marital debt gets put into the basket of things we have to divide, right? And how much gets paid out. And we do you can look at a gift or an inheritance, and you can look at the value on the date of marriage to date of divorce and see if, what that value was. So, but that premarital value is not considered in the divorce. So you put it all in, and you do the math on all the property to kind of come up with the final answer. But I just offer that because I think a lot of consumers don't think that way. I think they think, I've signed a mortgage, I've signed a note, the collateral is a home. That must mean that like I own this home too. And guess what? We put that money into the home where I've lived, and I've been here 15 years. And you need to understand what title means. You need to ask a lawyer. You need to have some people in your pocket that you can trust and just say, am I doing this the right way? Right? Like, this is what we want to do. Is this right? Are there other options? Just go out, get educated. We still do free consultations. A lot of law firms are getting away from that. I don't know about you guys. We still do them. Even if you have to pay some money for a consultation, that $50 or $200 you pay for a consultation is going to most likely be worth it to some degree to open your mind to start thinking about these things, right?
Yeah, for sure. I mean, and that's the problem is people go and they read somewhere on the internet, or they go do something that they think is a smart idea, and then later on it is a major problem in a divorce or any other legal proceeding. So talk to us about any other common problems that you see with respect to how spouses handle real estate as it relates to, their divorce.
Well, verbal agreements is just a big problem, right? He promised this, I promised that. We've always done it this way. Verbal agreements are as good as the paper they're written on. You have to get this stuff down into writing. You have to formalize it. It's just, and people are heartbroken when they get to the point. Most people, it's rare that I guess a divorce ends up with two willing participants. I mean, more often than not, it's one person who, was trying to maintain and the other trying to get out. And, those verbal agreements just fall apart. And people are very frustrated by that. They can spend a lot of time and money trying to go to court to essentially revive these things and maybe hope that the other party says, yeah, that's fine. I agree with that. So I think you just, you have to get things in writing. You have to formalize it, put proper title, call things individual or marital. And I think the other thing too is really that post when it's time to be divorced and figuring out, okay, how do I protect myself? We talked about that earlier, but making sure you have the right provisions that are in place to make sure if there's instructions that somebody is going to keep the home, just how you do that exactly. If you have real estate investments, you do need to think about that and really the cash flow behind that, who gets that cash flow, those are really assets, right? And they should be viewed that way. You have during the marriage, how that money can be used. And, post divorce, obviously, who can keep that investment. And I guess it goes back to also how it's held. So is it held, in individual names or as an LLC? Really what is the asset, right? And who is awarded that? And of course, if it's an asset, putting value on that. If we're talking about the income stream portion of it, that gets us into the spousal support and child support scenarios. Okay. We didn't really get to, touch on that, right? But we have a lot of people that come to us now that are in real estate. And we say, well, what's your income from it? Well, I don't really know. I'm not tracking it. Or, some people are way better than others, of course. Right. And they have their profit loss. We can take a look at it and figure that out. But some people are just not operating that way. And, they talk about it. Well, I have all these expenses and not really making any money and so on and so forth. And the courts in Wisconsin, at least, have to figure out what income is available for support orders, child support and maintenance. And that can include income from real estate investments, right? And so what you're doing there now is really a deep dive on the tax returns, if they have prepared them, okay? And figuring out what their expenses are, because the court could look at the expenses and decide that that's not a reasonable, although it might be a reasonable expense or deduction for tax purposes, that's a different scenario than what income is for support orders and family court.
Yeah. So the deductions you take as a real estate professional that, the IRS accepts, a court in Wisconsin would be like, yeah, you were out, going to these fancy conferences, real estate conferences, et cetera, and eating out and whatever. The IRS may take that, but we're not going to accept that for calculating support.
Yeah. At least on a high level, what we're supposed to do is zoom out and look at all the sources of income. And then from there, go back and determine if that is reasonable to use that income for support orders. And yeah, it might be a great tax advantage expense or deduction you've taken, but the concept is if you're an intact family, that money is flowing into the home, you're getting the benefit of however you've used that income. Like, let's just say it's like a cell phone expense or something like that, right? That compared to the spouse who's not receiving income in that fashion now has an expense for their cell phone. And that's a very limited, I guess, but one example of something that you could look at and say, well, is that really fair? Are they going to get that micro and look through your expenses to get down to that cell phone expense? They could. You really could. You could.
Yeah, we're gonna need a part 2 on real estate investments in divorce. Divorce creates such a complex story for the division of your assets. Well, Kyle, we really appreciate you taking the time with us to walk through this. Tell our listeners how they can find and connect with you. I know you're on all the social media channels and you got a YouTube page as well.
Yes. So we're growing that. I think the best way to connect, though, go to hkklawoffices.com, hkklawoffices.com. That's our law firm website. From there, you can find my contact information. My email address is there. It's kyle@hkklawoffices.com. And you can find links to our YouTube channel, Facebook, Instagram, and LinkedIn. So that's a great place to go there. If you want to check out the Meaningful Ideas Trading Club, we have a separate YouTube channel for that. Just type in Meaningful Ideas Trading Club. It will bring you there. We are growing our subscriber list, and we have lots of sessions that we are editing over this summer and putting lots of content out there. So we're excited to share.
Yeah, and for our listeners, we have put the links, all of Kyle's social media links, YouTube link, and his law firm website link in the description of the YouTube video. So you can go right there as well. Click on links, take you right to them. Kyle, thanks so much for being with us. Let's do this again.
Yeah, for sure. Thank you so much for having me, and appreciate you very much.
All right. With that, everybody, that is our show. Make sure to join us at 2 p.m. today for the collective. And next week, we'll see you then.
Have a good day, everyone.